Okay, good morning everybody, and welcome along to the second in the Community Benefit Society's webinar sessions. Today's session is going to be delivered by Stephen Phillips from Burness Paull, and before I hand over to Stephen to start presenting, I would just like to double check that everybody can hear me. So if I could ask just for a quick thumbs up or yes in the chat box which is on your dashboard, that would be fantastic. So if you could use your chat box, just let me, can I just double check that people can hear us okay? Reed's saying that the sound quality isn't great. Can I just double check, is anybody else having issues? Right, I'm not entirely sure what's happened here for the connection to be a bit juddery, but we'll just proceed. And if there are ongoing issues, if you could let me know, because from my point of view, everything is turned up full and switched on. Okie dokie. So I'm now going to hand over to Stephen. He's going to talk through a PowerPoint presentation, and if we could encourage participants to use the Q&A box on your dashboard. If you type any questions that you have in there, we will deal with those at the end of the session.
Okay, so I'm Stephen Phillips, a partner in Burness Paull Solicitors. I'm a lawyer, you can tell that because I'm wearing a tie. And I've specialised in providing legal support on community legal structures since about 1985-86, when I sat on what was aptly called the Legal Structures Working Party under the banner of Community Business Scotland. So yeah, it was something of interest even primary school stage. Today, the idea here is just to follow on from webinar number 1. First of all, a brief recap of some of the key points around BENCOMs as a refresher, if that's the right word, and then drilling into BENCOM rules just to give people a flavour of what they look like. They're not that wildly different from Articles of Association or Scale Constitutions. Just gives you a flavour of broadly what would be involved there. And then a wee piece on BENCOMs and group structures. I'm aware that there were some questions that James fielded at the end of his session around group structures, and just to give you a bit more information around that. And then finally a piece on conversion. So I'm going to try and time it to roughly 20 minutes, maybe a little bit more, and that should hopefully give us enough time for some Q&A at the end. So just a brief recap on BENCOMs. First of all, the name. Technically, the legislation refers to Society for the Benefit of the Community, which is a bit of a mouthful. Hence, it's normally shortened to CBS, Community Benefit Society, or BENCOM. And the legislation, again, you'll remember this from James's session, is the Cooperative and Community Benefit Societies Act 2014, not the Companies Act. It shares some of the same features, but is certainly not the same thing. And there are a number of quite significant differences. Registered with the Financial Conduct Authority, the FCA, rather than Companies House. And again, there's some significant differences in terms of how FCA carries out that role as compared with Companies House. Is governed by rules rather than Articles of Association or a constitution. It provides a clear legal identity, so there's a clear legal entity there in the same way as a company is an entity. So you've got a contracting party, it can hold property in its own name, it can sue and be sued in its own name and all of that good stuff. And it provides limited liability. So technically, if you want the detail in a BENCOM, any liability that a member has is limited to any amount that they've still to pay to the BENCOM for their shares. So if, for argument's sake, they've taken 100 shares and they've only paid 70% of the price that they were to pay for their shares, if the BENCOM goes bust, they can be called upon to pay the other 30%. In real life, mostly shares are fully paid up right at the start, and therefore, if the BENCOM goes down, there's no further liability for the members of BENCOM. two-tier structure is envisaged with a BENCOM, similar to a company. You have members, sometimes referred to as shareholders, because the only way to be a member is to hold a share. And you have the board. The legislation refers to the board as the committee, but as a matter of practice these days, people normally call it a board and call the people on the board directors. There is no list of statutory directors' duties. Whether you think that's a good thing or a bad thing is an open question. It probably means that lawyers can hypothesize about how far directors' duties would be deemed to apply. Certainly there isn't a nice, easy, straightforward list as there is in the Companies Act. And there's no wrongful trading provisions at present. So the issue for company directors of potentially allowing a company to continue to operate beyond the stage at which it should have ceased trading, and thereby potentially, at least in theory, incurring personal liability, that doesn't apply in the context of a BENCOM. BENCOM can get charitable status, obviously providing it satisfies the charity test, and interestingly, you can get charitable status even if you're doing a community share issue. That was one particular breakthrough that we made in the context of Port Patrick Harbour. So the way is now clear to have charitable status and to do a community share issue if you wish through a BENCOM. It can adopt an asset lock in its rules. It's not essential. The idea of an asset lock, some of you will be familiar with the similar concept for community interest companies, is that I suppose key protection is that if the organisation is wound up, you can't have a situation where the members walk off with all the assets. That's the kind of primary block, but it also blocks other transfers of assets not for the benefit of the community during the life of the BENCOM. Can be eligible for community right to buy or community asset transfer, providing the rules comply with the detailed requirements. I'll come back to that later. And the big thing for BENCOMs, and probably its main claim to fame, is the fact that there are special exemptions under the Financial Services Regulations that allow BENCOMs to issue shares in a much more cost-effective way than a company. And that's essentially why we're seeing more and more BENCOMs in Scotland. It's growing along with the growth in community share issues. And for possibly more of an ANRAC point, there are special provisions in the legislation that allow for transfer of engagements and amalgamations, and that can sometimes be helpful in the context of mergers between BENCOMs, but that's a bit more of a techie point. It's unlikely to be a key driver in choosing a BENCOM over other legal entities. Disadvantages very quickly, and again, James will have touched on many of these. The incorporation process can be simple and straightforward if you stick to the model rules. If you go out with the model rules, it can be long and it can be expensive. Not just expensive in terms of legal fees, although nobody minds paying legal fees, but also expensive in terms of the fees that you might have to pay to the FCA, which could be up to £950. The wording in the rules of BENCOMs tends to be less accessible than companies and certainly SCIO constitutions. The reason for that is because the legislation requires you to include a number of kind of fairly abstruse possibilities within the rules, otherwise you won't get past the FCA registration stage. And as I say, that does tend to mean that there's some kind of slightly obscure stuff sitting in there. Unfortunately, it can't be helped. The FCA, I think they themselves would probably acknowledge, a bit less user-friendly than Companies House. And the next bit, which I phrased in very diplomatic language, they take an interest in policy issues. Some people might regard that as a good thing because they help to protect the essence of a BENCOM. Some people might find it quite a frustrating thing in the sense that they develop their own policies on what is or isn't permissible, and it can be quite difficult to dislodge that in certain contexts. Also, and I think perhaps James touched on this briefly, there is a kind of open sort of ongoing test on the part of the FCA, at least in principle, on whether or not you continue to satisfy the requirements for registration as a BENCOM. And so in theory, they could apply pressure to deregister in a situation where they felt you were straying from the essence of what a BENCOM should be. Procedures take generally much longer than at Companies House, another point. And finally, not much of a disadvantage, more of a trap. Do not assume that procedures that you know and love from companies or know and love from SCIOs will automatically apply in the context of BENCOMs. The legislation is very different. And you do need to keep careful. It's certainly something that I've always emphasised to my team. Do not assume that the same thresholds and so on will apply in BENCOMs as they do in companies. And of course, less familiar to banks, landlords. I've put some councils because I know some of the people listening in are from local authorities. So the end of this seminar, of course, it'll be very familiar to all of you. So that was a quick overview of some of the kind of key features of BenComs. The next bit is just hopefully trying to kind of dispel some of the uncertainty that can apply around what rules look like. And I think partly driven by the fact that until recently, I would say this, but the rules tend to be quite traditional in how they're written. It tends to be pretty kind of heavy kind of lawyers drafting. And there are features in there that are less familiar to those who are more used to unincorporated association constitutions, scheme constitutions, articles, etc. Nevertheless, there's a lot there that will be familiar. The idea of the objects clause, obviously sitting in there and focusing on benefit of the community. Membership, there'll be provisions about how you admit people to members, and importantly, the only way of admitting somebody to membership rather, is to issue a share to that person. You'll also see provision for interest in a BenCom. You talk about interest on shares, not dividend on shares. And there will be provisions there in the context of, for example, a housing association. There'll be a clause saying that there is no interest payable in shares. In other contexts, obviously community share issue would be one. There'll be provisions allowing for what's normally a pretty low level of interest, but nevertheless enough interest to kind of interest people in investing. Withdrawal of shares is a big thing. So that's the ability essentially to swap your shares for cash. So you kind of cash in your shares and the company will pay you money. So normally that's on the basis of getting your original investment back after a certain period of years. But there's some fairly complex provisions there to protect the BenCom, allowing the BenCom to decline to allow shares to be withdrawn either for particular periods or until the finances improve or whatever. And there's also some techie provisions around death and bankruptcy of members about what happens to the shares in that context. So again, that's a set of provisions that you would not see in a company allowed to buy guarantee in the same form. And partly it ties in with some abstruse stuff in the 2014 Act as well. So as I say, some features in the membership section of the rules, which will be a little bit different for you. General meetings of members will be very similar. So provisions about how you give notice, quorums and all that kind of stuff. Resolutions and voting at general meetings, you will find probably more detail there in a set of rules than you may be used to in a set of articles of association, partly because the voting thresholds for certain procedures aren't laid down in the legislation, therefore you do need to kind of spell them out within the rules. Board level, again, pretty similar to what you would find in articles or a SKIO constitution, maximum minimum number, provision for elections, provisions for retirement, re-election, etc. Disqualification removal, again, very similar. Office bearers, again, very similar. Board meetings, again, very similar. One thing you might find in some of the older forms of rules of maybe slightly less rigorous approach taken to conflict of interest issues than we would normally like to see in a community organisation. So that's something worth looking out for. You don't always see, for example, as well, sorry, rather than an example, you also don't always see a specific provision prohibiting payment of remuneration to board members. So again, these are one or two things that you might want to be looking at if you're scanning a set of BenCom rules. Distribution of surpluses, again, a provision there which will, in the case of BenCom that's done a community share issue, it will allow for payment of interest, obviously, but it's about what happens to any surpluses, and normally it's a formula which talks about reinvestment of surpluses, and then the members deciding by resolution at the AGM whether any surpluses should be applied for wider community benefit, and if so, how much. And then some stuff in dissolution and winding up. Again, in most cases, a community organisation, the winding up provisions will talk about transfer of any residual assets to another charity or charities. But again, there are some aspects of the wording there that you'll be less familiar with, including the concept of an instrument of dissolution, which I have to say I've never actually seen, but if somebody ever finds one, I'd be interested in seeing it. So that's normal set of rules. This is a point at which we do the wee plug for Community Share Scotland and for the new models that I worked on with Community Share Scotland to try and I suppose smooth the path for community shares issues in Scotland. And essentially, this is work from the starting point that the community share issues in England and Wales have tended to focus on a share issue to buy the local pub or the local shop or whatever else, a kind of single purpose, single business type exercise. We were concerned that if, for example, a development trust wanted to use a BENCOM as its legal entity and wanted to do a community share issue, it would somewhat disenfranchise the members of the local community who were unable to invest. That doesn't seem to be a concern in England and Wales. It certainly was a concern here in terms of the long history of how community organisations are structured here. So the wheeze here was to have two classes of shares. Community member shares, where basically you just pay £1 and you don't get interest in that share as you would expect, and it's just a way of becoming a member. And then you've got contributor shares. The reason they're called contributor shares is just because the FCA refused to allow us to call them investor shares, but investor, I think, gets the idea across. It's for those members of the community or outside the community who feel that they have the financial means to actually provide support through a more substantial investment. And the way it's structured is very much along the lines of the community. Member shares dominate in governance terms. So they will make up a majority of the overall membership. They elect a majority of the people that are sitting on the board. But the contributor shares and shareholders have their place, in the sense that if you were outside the community and therefore not eligible community member share, you would have a vote in determining who would sit on the board within the category of contributor directors. You see that further there. So there's a little core of directors there where the contributors participate in deciding who should fulfill those seats. Hence, three categories of director: the community directors, the contributor directors, and co-opted directors. Co-opted directors, of course, would be a way of bringing on people with special skills and so on. So it's kind of optional, or people representing local stakeholder bodies. But again, that's an optional category. Community directors, certainly in terms of the way we structured it within the CSS model, must form a majority of the board. And there's a range of other provisions there that reflects community right to buy and community asset transfer eligibility criteria. So here we've got a set of BENCOM rules which allows those of limited means within the community to participate in much the way they would participate in a company limited guarantee type development trust or a SKIO development trust, but at the same time allows people to invest, and at the same time is eligible for CRTB and CAT, which is hopefully quite helpful and quite a flexible model for a development trust if you wanted to build in the idea of a community share issue. It would also work for a kind of standalone single community project if you felt those features were relevant and helpful. The other set of model rules which we put together, we call the CSS hybrid rules. And I suppose to understand the word hybrid, we need to sort of go back a stage, because the idea here was just to kind of recognize that for many community share issues in Scotland, it wasn't a situation of a group emerging from nowhere. More likely, there would be an existing community anchor organisation, most likely a development trust, and it has a particular project for which it wants to raise capital through a community share issue. But it's the development trust that's done all the running in terms of feasibility work and getting it to the stage where it could do a share issue. And therefore, it seemed anomalous that under the existing models, the BENCOM would essentially be totally independent and do its own thing. So this was an attempt, well, I should probably say more than an attempt, because hopefully we succeeded, to try and marry the well-established idea of a kind of wholly owned subsidiary of the Development Trust with the idea of having shareholders in the sense of investors through a community share issue. So we have two classes of shares here: contributor shares and the community anchor share, which is the share held by the Development Trust and which has certain veto powers, plus the ability to appoint a certain number of directors onto the board of the BENCOM. And we have a definition of community members within community contributor shares, as you'd expect. Now, that covers those investors who live in the local community, and that ties in then with the criteria that are required to reflect CRTB and CAT eligibility. Also worth noting that to ensure that the financial relationship between the offshoot and the development trust was properly robust, the rules envisage that there'll be a deed of covenant to make sure that surpluses are paid to the development trust. That's not built into the rules as such as a separate document, but it's recognised and referred to in the rules. Okay, just a little bit about group structures and just a little bit. It's a kind of topic that's probably best addressed in the context of actual real life case studies, so that may come up in the questions. Just worth noting, a BENCOM can have wholly owned subsidiaries, providing the subsidiaries are conducting business for the benefit of the community. So there's absolutely no issue in having wholly owned subsidiaries if that's what's needed. The BENCOM itself needs to be carrying on an industry, business or trade, because basically you can't be a BENCOM unless you're doing that. So one of the things, and maybe a misconception, is you can use a BENCOM to raise money via community share issue and just basically pass that money on and do nothing else. There needs to be something else happening within the BENCOM itself. If you want a subsidiary with charitable status, again, that is feasible. Again, I think that's a point that came up in James's session. A BENCOM can't be a wholly owned subsidiary in the normal way of another body, so you can't have a BENCOM with a single entity as its sole member. But if you want something close to that, the hybrid model that we put together for Community Share Scotland would give you most of the same features. Conversion, finally, a company can convert to BENCOM. So if you have an existing development trust, for example, and you want to do a community share issue, you can convert to BENCOM and do that. And we have cases where that has happened. A BENCOM can convert to a company. A BENCOM, if it's charitable status, can convert to a SCIO. And one of the aspects of conversion in this context is that you don't have to transfer property and other assets into the new legal entity. It kind of automatically sits there and you don't need to do that transfer. And that's quite a useful thing from the point, if those of you have gone through process, for example, transferring from an unincorporated association or a trust to a SCIO or a company, are aware of the additional hassle of particularly owned property as abandoned buildings, having to kind of transfer that in. You don't need that if it's a conversion process. Just to be noted, a SCIO can't convert to BENCOM just because of the way the legislation is written. And as mentioned at the start, there's some interesting but pretty techie provisions in 2014 Act that allow a BENCOM to merge with another BENCOM, again, without having to transfer land and buildings or other assets and so on, which again could make that process simpler. And I think that brings us to the end of the bit where I talk to you, and then I get to listen or see what your questions look like and decide whether any of them are ones that I can answer and how many of them I will have to pass on and come back separately on.
So we've already had a question in. Whilst we're giving everybody time to type their questions, I'm just going to also introduce my colleague Toby Sanderson, who's joined us from the Community Share Scotland team today. Toby is on hand to answer any technical questions or non-technical questions.
You to answer all the hard stuff.
So Toby's joining us as well. But the first question we have is from Linda. And Linda's asked, would there be lists available detailing the breakdown of community and contributor members to confirm levels of community members for asset transfer requests?
So yeah, in the sense of, if you mean lists available, you mean would the register of members specify the members within each category, etc.? And the answer to that is yes, absolutely, because it needs to be clear from the point of view of the legislation, you know, which members hold which type of shares, and with community share eligibility criteria are laid down in the model as, you know, in line with the normal qualifications there. So yeah.
Okay, and then another question, in the hybrid rules, could there be changes to recipient the deed of covenant?
Okay, so interesting question. Ooh, if you wanted to, I suppose, but the way the rules are, the way the model is written on the assumption that you would choose at the start who the recipient under the deed of covenant would be. and that would reflect the most common arrangement, assuming this is, let's say, a renewables project that's spun out from a development trust. The development trust would want to be named in the deed of covenant, and for the deed of covenant to have a lengthy period to run. And so the idea of the BENCOM just deciding at its end that it wanted to change a recipient would not be terribly palatable. Having said that, if you kind of scroll on 10 years and maybe the development trust is kind of fading for whatever reason, there's some other charitable local organisation that would be continuing to do good stuff and would be a more worthy recipient, then by agreement among the development trust and the BENCOM, they could put a new deed of covenant in place and amend the rules accordingly.
Brilliant. And another question that's come through, are there examples of community organisations changing to the BENCOM structure?
So, well, yeah, so the answer is yes. When we say changing to, there are, bodies, community organisations that have the company legal form that have adopted or converted the BENCOM structure in order to do our community share issue, yeah.
Brilliant. Are there any further questions that people would like to ask? Any further questions?
I should have landed like one of these kind of like Snoopy signs, free legal advice. Hold up the poster, or is it 5 cents? I can't remember. Whatever it's worth. Now's your chance, really. It's going to be a lot more expensive after this call.
So another question that has just come in, are there any issues of scale around the BENCOM structure?
Scale? Do you mean kind of be too toty? Well, I suppose the kind of rule of thumb that I think CSS tend to adopt is that if you're doing a share issue for less than about £30,000 and it's probably kind of not worth doing. At the other end of the scale, there have been community share issues for about 2.5 million or whatever. So again, that's perfectly feasible. So now there isn't any kind of defined limitation. It's more a question of at the small end of the scale, is it worth all the kind of work and admin, etc., etc., etc. And at the larger end of the scale, does there come a point where you might gather more investors by using a more kind of conventional non-community share vehicle rather than a BENCOM? But even then, who knows? Watch the space.
Anything you'd like to add there, Toby?
I think the guidance in the handbook is that you should have at least 20 members.
Yeah.
But besides that, I don't think there's any limits.
Fantastic, thank you. Any further questions that people would like to ask? I'm just going to give you, I'll pad this out for another couple of minutes, just give people time to type questions. What we will do is we will make a copy of the recording of this session available for those of you who've attended afterwards, and also provide a link to the first session that James did as well, just so that you've got the full complement of the sessions. Another question we've just had through is, how do BENCOMs sign documents, for example, leases?
Yeah, so normally that's done through a member of the board, i.e. a director, and the presence of a witness.
Okay, thank you. Any further questions to ask whilst we're all here this morning? Again, I'll just give a couple of minutes in case anybody's feverishly typing away and I've just not got it through yet.
It was a long question. How frustrating.
Exactly. I would hate to cut anybody off in their flow, but we'll sit here for another couple of minutes, and if there's no further questions that come through, I'll then move to close the session. Okie dokie, we're not getting anything through, so thank you very much for everybody's time this morning. And oh, there's one more. I've got something flashing at me. No, not a question. Thank you very much, everybody, for your time, and I will get that recording circulated as soon as possible. Thanks again. Thank you very much, Stephen, for coming through and doing this, and thank you, Toby, for being available this morning.